defense will be able to say about sudden, unexplained or unexpected death. And another is, yeah, that's the big one. But there were a couple of others that they were going to resolve, and I think they'll get that done. And the judge had an instruction that she was going to tweak, and they were going to listen. They were going to decide. I assume they're going to do this in open court, but it's at least possible they're going to be doing it. Oh, here we are. Here's our. I'm going to miss that fan, just so you know. I assume they'll do it in open court, but it's possible they'll do it in chambers. If they do it in chambers, we will know. We won't hear the discussion, but we'll be able to guess what the resolution was because of the instruction that she will give. Then she will give some instructions to the jury. Then they will go to closings. And I had someone from Massachusetts text me yesterday to say that in Massachusetts, they do it the way that I had described. If you recall, New Jersey does it. The defense will go first, and then the prosecution will do her closing, and then it will be done. The lawyers decided yesterday that they only needed about 45 minutes each. The judge said that's great, and I think you know that if you go past 45 minutes, you'll lose the attention of the jury. But she also told them she wasn't going to hold them to a strict time limit because the case was complicated. And so if they went over 45 minutes, she wasn't going to interrupt or remind them of the time. I guess she would if they go, it's not 45 or 50 or 55, but it looks like they're going to go 2 hours. I expect then she would interrupt, but I don't expect either of the lawyers to do it. I think the judge is right. If you go too long, the jury does lose attention. And so I think they're going to do their best to get it in the 45 minutes. So we'll have to see what they do or how they focus on closing. And I'll be interested in the defense because the defense cannot just repeat the opening, because if you recall, the opening has things in it referring to what Brian Walshe would say on the stand. And as we all know, he didn't say anything on the stand because he didn't get on the stand. And that means that some of the things that the defense referred to in opening, the defense will not be able to say in closing. So we should not hear anything about Brian Walshe getting up, going downstairs to clean the kitchen at 2 or 2:30 in the morning, taking about an hour, going back upstairs and finding Anna Walshe dead in bed, and then being shocked and thinking, I've got to do something because she's dead. And if I go to prison, what's going to happen to the 3 boys? And so his solution was to dispose of the body. And we heard clearly a lot of evidence and saw a lot of pictures of the trash bags and of what was found inside the trash bags, and all his shopping sprees to buy cleaning supplies and supplies to cut up a body. In his he was at Home Depot with the mask and the gloves. So we'll just have to see. I had an email this morning from a woman in Serbia. She actually sent me some articles, but they're in Serbian. So I speak English well, I think. But once you get me past English, my French is abominable, and my Italian, after many years of study, is not very good. My Serbian is non-existent. So she had offered to translate, and I texted her to ask her if she would do that, and I'll see. I don't know what. I guess in Serbia, they would be maybe 6 hours later than we are. So I'm at a little before 9. So actually, they would be up. It's not a bad time for them in Serbia. So if I get it before this morning is over, I'll see if I can read a couple and maybe summarize them for you. If not, I'll do a 5 o'clock recap, and I will do it then. If you're wondering where Joel is, he mentioned this yesterday. He is on his way to Tim Jansen's wedding, a daughter's wedding, not Tim Jansen's wedding, and they're in transit. He has a layover in Atlanta, and he's going to try to come in at least during that layover, but he's not confident about the internet connections. So you may be stuck with only me for this morning if Joel can't get in, but that's why he's not here. I am sure that he is sorry that he is not here watching with us uh, and listening to the closing arguments, particularly since he sat through the first couple of days of the interminable foundation as the exhibits were being marked for evidence to be admitted so that the jury could hear them. I think he would much prefer it if Tim's daughter had gotten married on one of those days, but that didn't happen. And I'm sure it's going to be a very happy occasion, and I'm sure that both Joel and Ileana will have a great time and a well-deserved little break. And as I think he said, his mother Carm is watching the three kids. So, but anyway, that's why he's not with us this morning. And so now it's 7 minutes to 9, and we haven't started yet. And I don't know I don't even know if I can see any questions if they come up, but if I can manage to figure out how to see them, I would take questions if you had any, but you may want to just sit here and relax until this actually begins, and I wouldn't blame you. But let's see what we're doing. Yep. So I think some of you were able to watch most or all of the trial, and there were a couple of, I thought, witnesses that were really strong for the prosecution. One of them I thought was Alyssa Kirby, because she could talk about her close relationship with Anna, and therefore her recollection of what Anna had said about the state of the marriage, how upset she was that she didn't have the boys with her, how exhausting it was traveling back and forth every week. She testified to the fact that Anna had said that Anna and Brian had not had sex for more than a year, which certainly speaks to the marriage not being in the best of shape. She also testified to Anna really seeming very stressed and increasingly so. And she was clearly a close friend, clearly very, very, very upset about Anna's death. She cried on the witness stand, and she was able to bring Anna to life for the jury, not some cipher that had been cut up and disposed of, but an actual living, breathing person who was a caring mother, who was a good friend, who was a very, very hard worker, who was a successful business person in terms of the real estate operation that she was doing. So I think she was a really effective witness for the state. Another very strong witness for the state was Jim Mutlu, who also talked about his close relationship with Anna. He was close to both Anna and Brian Walshe, and he talked about that relationship. He was with them on New Year's Eve, and he could talk to what things look like on New Year's Eve, and he was able to say that they seemed to be getting along, that everything was fine. But he also testified to cracks in the marriage, and twice said there was problems in the marriage, and there was trouble in the marriage. He wasn't supposed to say any of those things, but he did. He didn't do it deliberately. He just genuinely could not understand where the line was between what he was entitled to say and what he shouldn't say. And in fact, the information that he wasn't supposed to say 3 times came out during the defense cross-examination. So in that situation, the defense lawyer helped the prosecution enormously. They couldn't, the prosecution couldn't have asked for a better cross-examination because the evidence came in. And not only did the evidence come in, but every time he said something like that, she stopped him, which only emphasized for the jury how important that information was and how much it didn't help the defendant, Brian Walshe. So Jim Mutlu's testimony was really, I thought, very, very, very helpful. As you know, we heard from the keeper of the records with different titles and different jobs, but the person who kept the records at a couple of apartment complexes, at Home Depot, at the umbrella company for home goods, and then we saw all their video camera information, and there was a lot of it, and so all that came in. And through that we saw, the hatchet and the hacksaw, or not the hatchet, the hacksaw and the hammer, and all those cleaning supplies. I mean, a vivid picture that I think the jury will remember is Brian Walshe checking out of Home Depot with that cart full, way above the brim, with cleaning supplies, and there he is in gloves and a mask. It's quite the picture in terms of showing his activity, at least after the murder. And we're still looking at that fan going around. It's mesmerizing, isn't it? But I don't know why now it's 9 o'clock, and she told the jury to be there at 9 and wanted to get the other things done so the jury wouldn't have to sit and wait. Now it's showing 5 to 9 there. I think their clock is a little slow. Maybe theirs is correct and mine is wrong. No, I thought I'm on the Apple Watch, so I think I'm better than that clock. But in any event, they're late. And the jury, if they're not, I'm sure some of them have arrived already, but they're going to be there given their time in 4 minutes. And it may be that the trial won't start on time for them. Again, if the judge and the lawyers are in chambers and they're going over the jury instructions, then it may well be that they'll start on time. Yesterday, they did the evaluation of the jury instructions in open court. It isn't necessary that she does that in open court. They'll have somebody in there transcribing, so they'll have a record of it. It's just we won't see it. And maybe for some of you, it's not, wouldn't be a big deal anyway, because we couldn't see the draft that they were working from. So it wasn't the easiest thing to follow. So you heard that backup of my voice, or maybe, I hope you didn't, because it'll show how, amateurish I am right now. But in any event, we're waiting for oh, look, she's out there.
Brian Walshe, criminal indictment 2023-0091. Matter continues on jury trial. Counsel's present in court. Counsel, starting with the Commonwealth, kindly identify yourselves once again for the court and the record.
Good morning, Your Honor. Greg Conner for the Commonwealth.
Good morning, counsel.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Porter on behalf of Mr. Walshe.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walshe.
Good morning. We'll wait for Mr. Walshe, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference.
So we are doing the jury instructions. And this is day 10.
I don't know how many copies that is, but I think it might be enough. We need more.
You're watching
More.
either on
Side counsel until we get there.
Prof Joe Exchange or Surviving the Survivor.
Thank you.
All right. Good morning, Mr. Walshe. I said good morning to everybody else, so good morning to you too.
Morning. Thank you.
So since the version that I sent you at 1:55 PM, I've made the following edits. Either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties rather than have it as a separate to do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page, old page. Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, though.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it, or preferably strapped down to a hard board, it seems to me that that would be a good approach.
It's evidence and evidence.
No, Your Honor,
Jury.
we'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right.
But of course, she doesn't want anybody to use those tools and get hurt.
So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version. which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
So that's self-explanatory. She's got 2 versions of the instruction that really covers circumstantial evidence, and she preferred hers, but told the lawyers that if they can agree on the other, she'd be happy to give it because they're both accurate on the law. And for those of you who are here maybe the first couple of days of the trial, I had said to Joel that I couldn't imagine the hacksaw and other things going into the jury, because if they got into a heated discussion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine. Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference.
When she says draw from, then
Right.
in closing, they can refer to the language.
Other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that might have been a carryover of the plural version.
The 4-person,
I have page 12, reaching a verdict, the 3rd paragraph for each charge,
for the charge, yeah.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Only murder 1 is going to the jury.
Okay,
In the next paragraph,
and same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, 2nd paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
They're making it singular throughout. The instruction was reading as though there was more than one count going.
Your
into-
Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
She's reserving her objections. And that's for purposes of appeal.
Well, now I think most of the previous exceptions you made have been removed,
Just being cautious.
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a copy, all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
So they've agreed on the instruction. She said she was taking out the instruction on dangerous weapon. And I don't know whether that's because the prosecution and the defense have agreed that that instruction would come out. Yesterday, she was still keeping that instruction in, but the defense and prosecutor had said that they would talk about it after the trial adjourned and see if they could come to some resolution. So I don't know. I'm assuming that's what happened, but when she gives the instructions, we will listen closely to see if there's any reference to dangerous weapon in the instruction that's given. Now, the instructions, I believe the way Massachusetts does it is she will give some instructions before the closing, and then I think she may return and give additional instructions before the case is submitted to the jury. And we'll see if that's what happens. It's important that the jury gets some of the instructions ahead of time because it will help the jury make sense out of the closing arguments, particularly the instructions on what murder one is. I think it's really very helpful. So I'm assuming she will instruct the jury on murder one before the closing arguments. And that makes more sense. It makes it easier for the lawyers in closing argument to be able to refer to the instruction. So Maureen Conroy is asking, do the judge and attorneys know who are the 4 alternates at the beginning of the trial, or is there a system to pick randomly? I believe that Massachusetts picks randomly. Some states do it that way. New Jersey is one of them. You may have 16 sitting, but once the case is going to be submitted, they pull out the 4 who have become alternates. I think that's a better way to do it. I believe Florida, when you start the trial, they know who the alternates are. And I think that's not a good way to do it, because if there's a way that they do it each time, whether it's where the jurors sit or something else, it may be possible for the juror who's the alternate to figure it out. And, it's so much better if none of the jurors know who the 12 will be, because then they will all pay very close attention. If you have some inkling that you're an alternate, there may be a tendency not to listen quite as attentively as you otherwise would. And I think that's what Massachusetts does, but we will see. I believe we'll see that when we get there, that she will make some reference to it. And then what she will do is thank and excuse the jurors who are not sitting, but ask them to remain in case that there's an issue and they have to replace one of the jurors with an alternate. If that happens, as long as I have a little time, I might as well do this. If that happens, the jury will have to start deliberations from the get-go, because the juror who's now been added or replacing someone will not have been privy to the earlier discussion. So the deliberations will start again so that juror is fully cognizant of the full range of the discussion. So it sounds as though that this judge goes to her own computer, puts in the changes herself, and apparently is going to print them herself. Okay, Jeremiah MCG. How would I coach the Commonwealth and defense for their closing arguments? I don't know how to put it that way, because I'm sure they don't need coaching from me. But I do think, I will say something about the prosecution. I do think the prosecutor has got to stay away from the rabbit holes, make the direct case, and focus specifically and clearly on the evidence that will go to premeditation, and not get it mushed up with the evidence that comes the morning of January 1 and thereafter. Because I think what he's got or she's got to do is make clear to the jury that there is enough on which it can find that Brian Walshe, because this is deliberation, was considering murdering Anna Walshe, thought about it, and that's the things like thinking about divorce and, Anna Walshe dead, and knowing that she was having the affair and the friction in the marriage, and suspecting that she might decide now is the time, then he won't have the boys, and that might mean that he'd go to prison or jail, waiting sentence. So I think that they've got to focus on that clearly and then go on to all the gruesome details, or do the gruesome details first and then clearly focus on premeditation. The defense is going to focus on reasonable doubt, and they're going to poke holes and point to all the places where the evidence doesn't show that there was premeditation. Court Dawn Daniel asks if the alternates can go home. No, because it is possible that even after the case is submitted, one of the jurors will have to be replaced. Somebody could get ill during the deliberations, and then the alternate would have to replace that juror. So the alternates will have to be there until the jury reports a verdict. At least that's the way I think it always should be done, and that's the way I've seen it done. So let's see. I don't know that there are any questions. I'm looking at my chat on Prof. Joe Explains to see if there are any questions over here that I can see. Okay, this is Cooler by the Lake. What does the prosecution need to emphasize during close? Well, I just talked about that. And the premeditation part of it is whatever the evidence is that goes to show that Brian Walshe was considering murdering Anna Walshe before the early morning of January 1 when he did the murder. So it could be, right before he did the murder, because you can do all of that in a few seconds. You think about it, you consider it, you make the decision, and you do it. But for the jury, the prosecutor has got to focus on things in the evidence the prosecutor can show that Brian Walshe was considering it. And so that's going to have to be the things that week before December 25 to December 31, plus the information about them being in financial trouble, the information about Anna Walshe being stressed out and really, really unhappy that the boys weren't with her and seemingly considering putting an end to the marriage, the stresses in the marriage, Brian Walshe, Googling or using Safari to ask about divorce and what would be the best place for men, all those things. Every little, as the judge and the prosecutor called it, breadcrumb that shows that he was considering in advance. Doesn't have to be a lot. It just has to be enough from which the jury can say, yeah, there's enough there. When I put all this together, he was considering it. He hadn't decided to do it, maybe, but he was considering it. And then he decided and he did it. And his, all the evidence that shows that he, dismembered her, although that's not directly in evidence, will lend support to the idea, not necessarily that he premeditated, but that he decided and did it. And so that's what they're going to have to do. The other part, even in the cover-up part of it, there are a couple of references in the Google searches to murder, which is certainly the jury can use to say, of course, I don't know what they're going to be able, the defense lawyer, I don't know what he would be able to say about finding her dead, but he's going to be allowed to talk about she could have died naturally. So the references to murder certainly are things that the jury can use to say to itself, didn't die naturally, otherwise why is he talking about murder? So on the defense side, I think that will be one of the things that the defense goes out. They're going to say it was a happy marriage. They're going to go after all those things that show he wasn't considering murder before the early morning of January 1, that it was a happy marriage, that even her friends said that she still loved him, that there were no money troubles. Mother was paying for the rent. They had money in real estate. They could have borrowed on the insurance policies. The prosecution is going to talk about the insurance policies, and if she were dead, he'd have $1,250,000, which would solve the money problems that the defense says that Brian Walshe didn't have. But they're going to go after all those things. You heard some of it in the evidence. They're going to say the divorce queries had nothing to do with him thinking about divorce, but they were triggered by a movie, and that the movie was about divorce. And that's why those queries, I think they will make the argument that the references to murder was the Google search engine and the algorithm taking him to other sites where murder was referenced. It wasn't him asking about murder particularly. They're going to say that the reference to Anna Walsh dead on Christmas Day has to do with he hadn't heard from her and he was worried where she was. And remember, Alyssa Kirby testified to him calling saying, do you know where she is? And this is on Christmas Day. And then she testified that Anna Walsh called angry, telling her, I was only out of touch for an hour and a half, which undercuts the defense claim that he was worried and trying to find her and she'd been out of touch for hours. And the defense will do whatever it can to make the thing sound more complicated and to point to all the places that are reasonable doubt. So I think that's the way it will go. And as long as we're waiting, I will say reasonable doubt does not mean that every piece of evidence the jury hears the jury has to decide is true beyond a reasonable doubt. All the jury has to decide is the combination of all the evidence. Some of it may say, I think it's true. Others, the jury might say, I'm positive it's true. Other pieces of evidence, the jury would say, I've got my doubts about it. That doesn't matter. What the jury has to decide is in the complete analysis of all the evidence from which it can conclude guilt, it decides that the prosecution proved the case beyond a reasonable doubt. So maybe the judge is having trouble with her computer. She's having the same sort of technological problems that I run into all the time, because this is a long time to make what seem to be 3 or 4 editing changes and then printing out. But we will see. So let's see if there are any other questions while we're waiting. Okay. I think we're just, and I would like to say thank you to Betty Johnston, who's a legal scholar. It's really nice. Let's see. Some of you are not putting question marks in, but since I have time, I'm able to look more closely. I see Mary H. 1931 asking if the alternates can discuss the case among themselves while waiting. No. I think they're back in court, but we're still seeing the clock. No, they are not allowed to. They still are under the rules that the judge gives them about not talking about things, not testifying about things. Okay. Okay. Let's see if I see anything else here. Oh, Mystique Blue says, why the distinction among degrees of murder? Murder is murder. Not true. The degrees of murder go from murder 1 to manslaughter. You know, you may be in a heated argument and you grab something and hit somebody and she dies. And although you intended to hit her at the time, the fact that she died and you're responsible for the death is very different from, you know, lying in wait or poisoning somebody or hacking somebody up. You know, premeditation requires that you really considered it, then decided to do it and did it. Intent says you didn't have to consider it, and you know, you didn't have to all this in advance think about should I, shouldn't I, you know, what's going to happen. You just, at the time you do it, you intended to kill. And that's different from the person who's had some time, even if it's only a couple of minutes, to really say, let me think about whether I want to do it. Let me work this out. Can I get away with it? Would I use a knife? Would I use poison? You know, what are the consequences going to be? How am I going to cover myself after the fact? And then decides and does it. That's a different defendant from the one who right in the moment says, I've had it, I'm going to kill. And so those are the different degrees of murder. And it's not just murder that has different degrees. The mental state by which you do the act affects other crimes also. Or is this, and I shouldn't say affects, but it's an element of other crimes also. Okay. Let me see. You hear my sing song because I'm reading and we're still waiting to go. And there's the clock telling us that it's now 9:25. I'm doing a great commentary. I'm even telling you about the fan whirring around and the clock on the wall. We'd be much better if I could talk to you about something that's actually happening related to the trial. Okay, this is coming from Norma Parrish. List all the prior evil deeds so we understand how evil he is, like the theft from his father, years of art fraud, hiring chefs to cook for 10 or so friends, and then delaying paying. Well, those are the three that I would have said that he engaged in. And the one that you didn't list, that of course was too remote to be able to be used, Anna Walshe, before they got married, had filed a police complaint that Brian Walshe had threatened to kill her. And then the complaint was withdrawn. So that's another one you could chalk up to him. So those are the four that I can.
Now, session, have your cell phones, please.
Now we're going to ask the jury the 4 questions.
Everyone all set? Good.
All rise, jurors entering.
Oh, we're going to hear that great, oh, hear you. I hope.
Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Justice Diane Frenier,
Justice of the Norfolk Superior Court, Ron here, give your attendance and you shall be heard. Let's have the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn up your cell phones.
Make sure there's a lot of that everything else. Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are you able to comply with my order that you not speak to anyone about this case?
Yes.
And you all still have open minds?
Yes. Thank you, Hannibal, TLC.
Those 4 answers for the record all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then depending on how you're doing, given the time that's passed since then, we may have a short break, bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence.
Nice for her to say it, but she's also protecting the record.
Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walshe is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walsh to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walsh committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walsh does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walsh does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walsh beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walsh guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walsh is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walsh is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walsh is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder.
Ah, so it is both going in.
Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation. And then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walshe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case, murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you.
Ms. Annie Kay, it sounds as though the Massachusetts lawyer, who was a defense lawyer, a prosecutor for many years, did not tell us what the Massachusetts law was correctly. It sounds as though murder 1 and murder 2 automatically go to the jury. I have her email, and she was clear that she said you have to request it, but this doesn't sound like you needed to request it. Idaho PUD girl, yes, they can talk about what premeditation means during closing arguments, as long as they're accurate. They can do what Joel Ritter said he used to do, which was liken it to going to a traffic corner with where the light is turned yellow and deciding whether to go through or not. He does a great job explaining that.
There that long. You're going to go for a stretch now. So I'm going to ask you to stand up. As I said to you before, shake a leg.
Thank you, Cohen's anthem. It's Yas, YAS, the woman who's doing the closing for the state, for the Commonwealth.
When you're ready, please be seated. So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. As to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
It sounds as though it was her effort to counter what happened in opening. I don't know how much was added to the normal instruction that you would give on what lawyers say is not evidence, but it sounded as though there was more.
What could happen to a loving father and a loving husband? We're making live of police before they search for the unspeakable on the internet. Exposed body of the woman that you adore. Government suggests it was an affair. There's no proof of that. There's no proof that Ron Walsh knew anything about an affair between the woman he loved and William Dixon. Money? Second reason that the government suggests, family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of the three children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up and something that he did. So what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Ron Walsh? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walsh was a loving father and a loving husband? We know from much of the testimony of Jim Motlow. We know from simple testimony from Julie Basler from KinderCare. When asked questions about her experience with Mr. Walsh and the children, that he would show up and he'd be interested and he'd be friendly. And he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walsh trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of the body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. That he ever planned to harm. That he ever intended to harm. So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walsh. You will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walsh. You can't base your verdict on anger to what Mr. Walsh did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are. The obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Mutlow's testimony, where for almost an hour, he talked beautifully about the love between these two people, that he talked glowingly about Mr. Walsh. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem, and reflect upon the evidence that he gave of a phone call he had with Mr. Walsh on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walsh leaving. The lie that Mr. Walsh was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walsh leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walsh, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. We need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation? In thousands of pages of records. I suggest to you respectfully, you're the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Did I please have exhibit 201? And next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest with the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walshe killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. Digital data, talked about that briefly, but there is nothing in that data, all of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other fellow jurors say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt to a moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers, of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walsh, Brian Walsh, as adults, enjoyed their life together and had spent their life together, perhaps every night before she moved to DC to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence like blood can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood, that test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Salim, the profile of those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house. And that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet, and you should. If there is no evidence of any killing that happened, and there's no evidence that anything was done before Mrs. Walshe died, and there's no evidence of premeditation or anything, there is evidence of lying and disposing of the body. You can take that to one stage. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. No, I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why. They just give it to you. They do the same thing with the searches. Remember when Trooper Prof was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walshe, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing back pieces of evidence. Why? Why were you given? Why was Trooper Prof asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I will encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino. Something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walshe, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all the things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug that is in evidence that has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walshe, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walshe? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walshe is talking to the police and he says, I messenger. When asked about, and he was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walshe had seen text messages between Anna Walshe and William Fastow. And those text messages between Anna Walshe and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walshe saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them, but ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence that Mr. Walshe ever saw any text message, because he was trying to say, I messenger. And now you know from the testimony of Trooper Keith, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walshe ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walshe is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walshe, as she and Jim Mutlow were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walshe? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutlow really took efforts to remember, and then he said, oh yeah, that happened right before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walshe reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fasto, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walshe worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe you. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walshe and her husband, Brian Walshe, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in DC, talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate.
He's now over his estimated time.
So, context. Once again, divorce. About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that, once again, just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. And we get to New Year's Eve. We get to a festive event, jovial, laughter, love, described in various terms, various ways, not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in D.C. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa Kirk. Could I have exhibit 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we're talking about the feelings and the emotions and the state of mind of Anna Walsh and Brian Walsh, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. It's at 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walsh talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing about the state of mind of Brian Walsh at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead and Lynn. Exhibit 59, at 1227, those records indicate that Mr. Walsh credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walsh lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walsh loved Anna Walsh, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walsh. None whatsoever. Mr. Walsh is not guilty. He's not guilty of murder. Thank you.
George Kentz, why don't you take a moment to stand up?
So I see a lot of people in the chat thinking that wasn't effective. I actually thought it was a really good closing for the defense, given the evidence he had to work with. I'm not sure the shouting or the, you
When
know,
you're
the
ready, you may see.
vocal emphasis was great. But boy, I think he really did a good job of poking or pointing out the places in the
Yeah,
constitutional case.
closing argument of the Commonwealth.
88 yes.
Yeah, let's see how well she does in making the case for the prosecution.
You may proceed.
Thank you, Your Honor. Anna Walsh is dead. Anna Walsh is dead because he murdered her. And he intended her death. Anna Walsh is not listening. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to DC for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walsh has not been seen by her friends, her coworkers, or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. After he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death. And the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. The photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fatsow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walsh and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white
towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this, because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Vin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walsh dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his reported interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating from the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st of 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastow told you that Anna was very active. They did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution. The case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, the family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent 1 day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and then Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Fastow on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to keep them. Anna quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna, and And on December 29th, Anna spoke with Jen Lutu and told him that she was upset about the travel, that being separated from the children, upset about the defendant's schedule. It was ongoing. It's getting to be too much. On December 29th, Anna went out with Alyssa Kirby. And she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in DC, and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. His home, the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in DC and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Fastow. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her And he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his math book was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives, but because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went to put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then she, I remember her putting her phone upstairs because then she came back down without it.
Was Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at, he went to bed and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting or a tie-back suit and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, but she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of a body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirm this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. In his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, since he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was humble. But Alyssa Kirby texted him on January 4th asking about Anna. And so he called Tishman Spire a few minutes later and started to pretend to look for her. He called Will Fastbell, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not panicked. The police were coming to the house and to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Missed you. The defendant prevented anyone from ever finding Anna's body. There was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body. And all that remains of Anna are 2 hairs, some blood, and a few things that belong there. Part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster, his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a bond. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate, and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench.
Okay, we've heard both of the openings now. I said I thought the defense was effective given what the defense had to work with, poking holes in, what he considered the soft spots. I thought she was, I don't know what you thought, I thought she was also very effective, in particular, the chronology at the start that she gave with regard to the knife and going out and disposing of, some trash before he went and bought anything, before the cleaning supplies or anything else. And buying I thought was particularly effective was on that run, the first run, he also bought antiseptic cream.
You're my guidepost. You need a break to the bathroom. Okay. All for one for all.
And remember, he had
Right to the bathroom.
cut on his finger.
When you're ready to come back out, I'll be at your disposal.
All right, please.
That's a particularly effective, I
There's
thought,
Homie.
chronology. I wish she had said something about the forensic expert saying that you can't pick up, a really, really good cleaning at a high degree of temperature, which is what a dishwasher would be, I believe, that you can destroy all evidence of blood or DNA. At least that's how I remember that testimony. But how did the rest of you think that closing went? And she got in, which
Give
I'm
you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts.
the crimes, yeah.
And asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walsh that wish to provide information. And I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the
I think there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
So victim impact statements in murder trials come at sentencing, and that's what that discussion was. As you recall, she deferred sentencing on the 2 counts on which he pled, that is the lying to the police and the disposal of the body, and she wanted to hold off until after the verdict in this case. And now she's prodding the prosecutor to get those statements to her. And you heard the prosecutor. They've got issues with the family statements, and to the extent they may implicate the privacy interests in the kids. And she said the statements, the judge said that she agreed the statements would be impounded, which sounds as though we may not hear them because of the privacy interests, but at least they're trying to collect them. The judge is being very efficient. She does not know when this jury will come back with a verdict, but she wants to be ready to go on the sentencing. Questions here? Again, murder 1 and murder 2 is going to the jury, and I kept saying all along it wouldn't, because in Massachusetts, one side or the other had to request it, and that came from a Massachusetts former prosecutor and defense lawyer, and that information clearly was not accurate. So the murder 1, murder 2 are going to the jury. The defense claim was it doesn't matter whether it's premeditated murder or intent. There's no evidence that he caused the death, and no evidence in addition that he either intended or he premeditated. So that's the place that I wish she had done a little more as the prosecutor, to emphasize that the reason why, to some extent there's an absence of compelling evidence is because he disposed of the body. She hid it, and she did a good job hitting it, but it would have been nice if she had gone out, she had hid it a little more strenuously, I guess would be one way to put it, or forcefully. Okay. Okay, I will say with regard, because I know I'm going to get questions once the case is given to the jury about how long I think they'll be out. So I will say this now. If they come back quickly, it's going to be, it clearly will be a conviction. If they come back really quickly, my guess would be it would be murder one, unless they all get to agree that it can't be premeditated and then they move to murder two. If they're out a while, it doesn't mean they won't come back with a conviction, but it does mean that they're wrestling with some of the issues that the defense has raised. Okay, questions here? Oh, Amber said she enjoys her, she enjoyed the prosecutor's closing, that she brought life to the arguments. I think she did a good job of relating the dates to the information. And we couldn't see, and I don't know why the pool camera didn't show us the pictures, because I'd made a note to myself, she really needs a video or something to show how, jovial he was when he was shopping. But it's pretty clear that although she didn't do a video, they posted a picture of him smiling in the store as he's shopping. We just didn't see any of them, and I don't know why, because the rest of the trial, the rest of the week, when there were photos or documents posted for the, inside the courtroom, the pool camera always moved over there pretty slowly. You could see the camera moving slowly over and showing it to us. So maybe they have a different cameraman today, but it would have been nice to see, while she was doing the closing, what she was showing to the jury. All right. Deep Thinker Deb, did they find 5-gallon buckets at the house? I don't recall. Does anybody in the chat remember? And I do think it was really useful for the prosecutor she didn't put a lot of emphasis on it, but she at least pointed out that his problem, because the defense made a point of he was such a good father that Anna trusted him with the kids. Well, in fact, he would be going to jail if he didn't have the kids. So I'm sure she trusted him with him, but it wasn't, the reason why he had the kids had to do with he would be in jail otherwise. Okay, I don't see any question. Oh, here's a question mark. No, those are 7. Sorry. They looked enough like a question mark. When I read fast, it's hard. And by the way, apologies for the typos, but I'm trying to listen to the trial and type at the same time. And in any event, on the phone, my phone is a narrow phone, and I end up, hitting the wrong key all the time. And then when I'm trying to do it quickly because of the trial, I don't go back and proof until it goes out, and then I'm just ashamed of myself. Did I see or hear an interruption from the gallery? I did not. Did anyone else see or hear it? The judge did not say anything, did she? Not that I heard. I did see the officer, at one point he blocked out the camera. Is that what you're talking about, Amber? I mean, I saw that happen, but I didn't hear anything that prompted it. Okay, it seems to me that people are responding in the chat, think she did a really good job in closing. I do too. Yeah, Kathy Barella 4304 says she would have said, does an innocent person dismember a loved one? So would I. And I would have emphasized he's so much in love with her, and yet, he's methodically chopping her body up. Okay, Karen Lee says disagrees about both closings. She said the defense was not believable, but the prosecutor brought it all home. She was phenomenal. Okay, so she thought the defense was not believable, and she thought, I'm paraphrasing now, that she thought the prosecutor was phenomenal and there were no holes in what she did. I think the prosecutor was very, very good too. I just think there were a couple of places where she could have been better. And we do disagree about the defense, but you know, that's what makes what is that? That's what makes a salad. I guess I'm a little olive in the salad and you're the cucumber. And you know, what we're reflecting is, you know, in part what members of the jury might be thinking. Not that they're grading the performance of the jurors necessarily, but you know, how persuasive they think the closings were. All right, I don't see any other questions, so maybe we'll just stop. Did anybody hear how long she said this break was going to be? Because I did not hear it. Barley Hops wants to know if convicting is sentencing the same day. It depends on, you know, usually you get a pre-sentence report, and it depends on whether the defense wants to waive, and they may have already decided this, waive the acquisition of a pre-sentence report first. If it's murder one, as I understand it, it's life without parole. And if that's the case, then a pre-sentence report can't affect what the judge what the judge's sentence is. If it's murder two, then a pre-sentence report may be very, very important. And in addition, she still has to decide on the disposal of a body if it's a murder conviction, whether she's going to go for the maximum of 10 years and move up past 10 to, you know, 15, 20. And I have a guess, and it's only a guess, so I may find out that, again, I'm going to be proved to have guessed wrong. But my guess is if it's murder two, and somebody in the chat can tell me for sure what the maximum sentence is for murder two, I think it's after 15 years you can be paroled, but I'm happy to be corrected about it. But my guess is that if it's murder two, she is likely to sentence to the maximum of 20 on the disposal of a body and maybe run it consecutively to be sure he's in prison a long time. Okay, then let's see if there are any other questions. I don't see anything else. Bathroom break, but she didn't say how long. Well, she should have given us a time, you know. Okay. All right. So I got another question about the sentence for murder one, murder two. I'm pretty sure murder one is life without parole. I'm not as confident as to what murder two is in Massachusetts. It's still life, I believe, but I'm not confident as to the mandatory minimum that you have to serve before being eligible for parole. I think it's 15 years, but boy, I wish somebody would correct me. I really wish somebody would correct me. About it. Because I would like to know, and I can't, if I try to go off this to try to find okay, murder one, this is Patches, thank you. Murder one is life without parole. Murder two is 15 to life. Okay. Thank you.
I just
Thank
saw
you,
somewhere
Patches.
that everybody thought the small edit I made to the verdict slip and everyone's fine with it. Is that right? Everyone's nodding. Thank you.
So I don't know where Joel is. They were changing planes, I believe, in Atlanta, and he was going to try to get on if he could get internet connection. So maybe he will get on. I don't know whether he's,
All right, to the court, please. Jurors entering.
but I see some messages from the COE that suggest that they are able to listen. And I don't know where they got on, but we've had both closings, and we had initial instructions from the judge to the jury. And we learned that, Joel, despite what we had heard from the former prosecutor in Massachusetts, that the murder 1 and murder 2 charges both go and you don't need a request.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate it. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the slip, verdict slip, and in a little while I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walsh is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walsh's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence. And you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide. which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. And in those types of cases, we allow a person with specialized training or experience, call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial.
Let's hear this.
It consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those. Because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true. but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walshe allegedly made to William Fausto, Jem Bootlew, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, Motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called completeness of guilt. Spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walsh after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientation, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible. And that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the court and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. That's the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys.
Where's she going? Oh, I guess they're gonna draw the, yeah, I saw somebody in the chat say it would be really terrible and disappointing if you sat through all this and then your name is called and you don't actually get to deliberate. I agree, absolutely. Imagine getting up every morning, sitting there all day, coming in yesterday and going home, and then you don't get to participate in the decision. It would be awful. I don't see any questions here, so I guess we will just wait. So the instructions she gave were obviously, they should have sounded to you as pretty standard, but she does a really good job, and I love the way she.
A four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the foreperson of this jury.
So that was done randomly also, evidently.
Our clerk is now going to randomly select 4 of you from among all the jurors except the foreperson to serve as alternate jurors.
You know, that's tough because some people are not naturally.
What's happening is juror number from seat number 6, juror number 138.
Not naturally organized or leaders.
Thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6.
Well, I heard that noise, whatever it was.
Grab me, then no booking the Solomon.
Our next alternate is juror in seat number 5.
The two sides are not giving any indication whether they're happy at the ones who are being pulled out or not.
Juror in seat 15.
Has that officer been standing there the whole time? I'm sure not. Why is he there now?
Juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into the concluding remarks. And that is, I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001 on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are 3 options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson. in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in court officers.
Which you solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they be. You will not speak to them or suffer anyone else to speak to them except by order or will ask if they need it. So,
I will.
So now the deliberating jurors, the 12 of you, are going to go and start your private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all rise, please. There's take your notebooks with you and follow me.
Okay, now we're on the clock. Look at that. The 000 is up there. And they went out at 12:24. I guess I'm the timekeeper here. So now you can all of you in the chat can now enter your guesses as to.
As I said to you at the side of the bench, there's some small edits and in fact.
Gally Sinatra said 12:23.
Some small edits that I need to make to the instruction. And I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with that. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they going to secure it yet, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in. And of course, our court staff as well, court officers, want to take a look at those to make sure that they're comfortable with what's going on.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
You have a roll, they can do it themselves.
We have a roll. We can give them scissors if you want.
Well. Cut them off.
I'm getting a
That's why I
question
put that out there.
about how long I think the jury will be out.
Thank you.
I will tell you how long, if I were on the jury, it would take me to vote.
10-minute rule, which means at all times, Madam Clerk should be, the whole community should be able to return to the court within 10 minutes, all right? I won't take it further between the hours of 1 and 2 on any day, with the opportunity to attend to your other work.
Thank you, Ron.
All right.
The first time it came out, I would vote guilty on murder 1. Maybe. The only reason why I might not is to have more of and this is kind of a tactic of a juror, to have more impact on deliberations if I've already taken an early position on what I'm going to do. And that would be a read of the jury. I don't like it when they select a juror out of the hat because, as I said, some people are natural leaders. Some people are very organized. Some people have a good sense about how to run a room and how to do, how to handle a group. And some people are not. And it's frustrating if you're in a room where the person who is leading is one of the ones who is not. So I don't think I, would be happy with it. So we're now on the clock. Clock is starting to tick. Look at that. We're at 1:58. And I don't know that I have anything else to say. We're not going to be back now until the jury either comes out with a question or comes in with a verdict. I can tell you that not just if you prosecute, but if you're a trial lawyer, this period now is the most stressful of any period at all. And it's certainly true in a criminal case where the prosecutor has the burden beyond a reasonable doubt and defense is facing some pretty severe consequences. You can't get anything else done. You can't think about anything else. All you do is obsess about, I could have done this differently. I should have done that differently. I wonder how the jury is going to think about this. Can't get anything done. And I have never heard a trial lawyer who has said anything other than what I just said. So the prosecutors and the defense lawyers will now go out and just sit and fidget. So you now have a picture of what they're up to. So I don't know. I guess unless I see some questions, I guess we're done. It's hard to believe that that's what I'm saying, but it looks like we're done until we have word that there's a verdict or a question. Okay, Elizabeth King says she wants me to know how long till the jury verdict. I just told you I gave what I would do. I can't. I'm not good at this. I hate making those sorts of calls. I was better in the Adelson trials because I just thought the defenses were so ridiculous, and there wasn't an issue of, are you going to be able to prove intent or premeditation because you don't have a body there, or prove that the death was caused by the act of another as compared to, an accident or a natural death. So this is hard for me. Besides, I'm reluctant to do this since I told you last night or day before yesterday, I was sure he was going to testify based on the opening, and it turned out he didn't testify. And then on the murder 1, murder 2, that one I don't blame myself for because we did consult with a Massachusetts former prosecutor and we're told that there would have to be a request. But still, I don't like saying things that are not right to you. I like trying to be right all the time. I know it's impossible, but boy, I hate it when I'm wrong. And that said, I really don't do well at this. If you really push me, I would say 2 to 3 hours, but I don't know. All I do know is the longer it goes, the more likely it would be a hung jury. Because they're hung up on something. And if they're not disturbed by the fact that he did the killing, that doesn't hang them up at all, then the issue is going to be whether they think there's enough to hang their hat on intent or premeditation. And the more I think about it, I wish the prosecutor had done a little more on premeditation. She didn't go back and review with the jury, here's what it means, and then go into the recitation of the evidence. And I wish she had just done that. But there are a lot of people in the chat who thought she did a really terrific job, and they're not as kind of nitpicky as I can get. Okay. I don't see any questions in the chat, so yeah. Okay, here's one from Rick Grimm. How would you convince a juror who can't vote murder 1 that there was premeditated action? I do not think, and this is not just juries, I don't think you can persuade someone of something else by harangues, or any kind of, sense of exasperation. I think what you would have to do is hear that juror where the problem is that he's having with seeing premeditation, and hear him out on it, and then go back and look at the evidence that could address the question, and give him a chance to talk about it, give him a chance to think about it. The last thing anybody who seems to have made a decision wants is to have everybody else yell at him or say you're wrong. Those things are never persuasive. But to hear him out respectfully and, to say, I can see why you feel that way. would you mind if I go through and talk about the things that persuade me? I think is probably the best way to go about it. Okay. Any other questions or are we? Nope, we don't have any other questions. I'm going to do a recap at 5 as I've done the other nights, and maybe by 5 we can recap and we'll have a verdict. And I had a lot of requests from people. I did that holiday, that song Romeo and Juliet to what was it to? I don't even remember what the song was to. And I've had a lot of requests. So if the requests keep coming in, and if I get some likes, so I feel as though I'm being, you really like what I'm doing, I'll find another song. I think it would be Julius Caesar. And I don't know what the music is to it. But I'm thinking about doing that tonight, and maybe we'll have a verdict. We'll keep our fingers crossed. Okay, so we're done until the verdict. And those of you who are going to be on at 5 with me, I really welcome you. I'm really pleased that you would like to do it. And I do not believe, because Joel and the COE are at the Jim Jansen's daughter's wedding, that there'll be anything tonight that they're going to be doing. But check on the Surviving Survivor channel, because there will be an announcement there. You wouldn't want to miss it if they are going to be doing something. So thanks a lot, and see you at the verdict. Ciao a tutti, and thank you very much, Profers. This is Prof. Joe at Prof. Joe Explains, signing off. And although I signed off, the feed is still live, and I'm going to see if I can find out whether the feed will stay open for the verdict watch. I don't know the answer to this, but let me check. I don't see an answer for any of you who are still here. Maybe you're all gone by now, but it's still open. So certainly, at least for a while, it's going to be kept open to see if there's a verdict. But I am going to be moving away because I've got a couple of things I have to do, but I will keep checking back. And again, let's hope this verdict is quick. I hate waiting, just so you know. Somebody told me yesterday I was really patient, and I said I am not. And this is going to be a good example of how patient I am not. So, ciao a tutti.
Seated, court's in session.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that we, there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo
189.
52 should say something other than butcher paper.
Yeah. And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout. So what is it? That is, that term is used in other numbers. So is it something about that particular photo that is problematic with that description?
Oh, I just don't like it, but,
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
that's right.
Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
That's, other than that, that's the only,
Was 189.
blood clots and.
Hi, everyone. Has anyone been here the whole time to know what this is about? I just was able to get back in on the stream. I'm seeing something that says the defense is asking the judge to dismiss the charges. Is that what I'm reading? Well, why are they doing that once it's been submitted to the jury? Normally, if you want to make a motion to dismiss based on insufficient evidence, you do it before it's submitted to the jury.
Aside from that one suggestion, the change.
Okay.
Or notwithstanding the verdict, but not once it's submitted while the jury's out.
This one?
This is really peculiar, at least in my experience, peculiar. If
All right, so I'm going to write back to the jurors and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97. And here's an exhibit list to assist you.
Thank you, Your Honor.
It must have been a jury question. Boy, you missed the first 2 minutes and it's impossible to figure out what's going on. Although I thought I heard her say, this is what she'll tell them. Did I hear that correctly? If so, it's a jury question.
Here you go, Madam Clerk. If you want to look at it, you're welcome to. It's pretty straightforward. Thank you.
Court's in recess.
Well, I don't know what to tell you. I missed the first 2 minutes, and apparently those 2 minutes were really important. But did anybody hear it? I thought what I heard her say, but boy, I'd be happy to be corrected, was something about she would mark it and tell them it's the photo, which made it sound as though it was a jury question, but I'm not sure I heard it correctly. But the motion to dismiss, which was also somewhere here, I don't believe that could be correct. Well, I'm sorry. It seems to me I failed you. I'm 2 minutes late and I can't work out what happened. And it's frustrating. Nope, I don't. And there are no questions. Of course, most people in the chat are not in the chat. They're out doing things, not expecting that we'd be back here so soon. Well, maybe I learned my lesson and I'll just sit here rather than try to get anything done. Amber said it was a jury question about quote unquote butcher paper. So my guess that it was a jury question was correct. What I heard her say may not have been correct because I'm pretty sure I thought I heard her say photo. So is it a photograph of butcher paper? And I don't remember butcher paper. Is the butcher paper something that they said he bought and then he put it under on the basement floor? Does anyone recall what a reference to butcher paper is about? I thought I had a list of everything he purchased, but I don't remember butcher paper. Maybe we'll get help from someone in the chat. But that was a pretty fast, matter-of-fact answer from her, wasn't it? So how long, what's the clock? It's 3 hours now? 3 hours, 7 minutes, and 20 seconds. And they must have had lunch over part of the time. So they're working on it. And the question is, what would...
Hey, Joe, do you want me to try to re-rack that for you?
Yeah, if we could get that. Hi, how are you doing?
Hi, I'm good. I just walked into the hotel room.
Yeah, if we could get the very first part. I mean, by the time I got back here after the alert that they were on, she was in the middle of it. And I heard her. I heard enough to be able to say it was a jury question.
Okay, cool. Give me 2 minutes.
Okay, thanks a lot.
Let me get it up here and then I'll flag you.
I appreciate it. Thanks a lot.
Okay, great.
So they're going, well, what we know is they're going through the exhibits. because clearly whatever this is, butcher paper was one of the exhibits. And they had a question about it. Here's where you get in. This is like going into a deep rabbit hole, trying to figure out what it is that the jury means when they ask a question. And I think most lawyers would say, generally, when this happens, they rack their brains guessing and they're wrong. Because it's, once in a while, it's pretty easy. It's pretty easy to make a guess, but the question, well, we're going to wait and see what the COE can pull up from the very beginning, because it has to be, and what's interesting to me is it has to be significant enough in terms of their deliberations that they had the question about it. But what would be significant about this exhibit? Well, let's hope we hear it from the beginning and we will know. And I don't see any questions from anyone. I guess they hear me sufficiently befuddled that they figure it's no use asking me anything, which probably is true.
All right, Joe, I have it ready here.
Okay, thanks.
Apologies. Joel is watching the closing arguments all over again here in the background. But
Okay.
I'm going to mute myself. I'll pull it up. And then whenever you're done with whatever you want to do, just let me know and I'll pull it back down.
Thanks a lot.
Okay, great.
Here we go.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that we, there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout. So what is it? That is, that term is used in other numbers. So is it something about that particular photo that is problematic with that description?
Oh, I just don't like it, but.
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
That's right. Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
Okay, so we don't know what the particular question was, but reading between the lines, the jury is asking for a particular exhibit, and they want to know what number it is in order to locate it. And the judge and the lawyers agree it's exhibit 97, I think she said. And she also said that she typically gives the jury an exhibit list that they can look at when they're there. So they wouldn't have to come out and ask this question. They could refer to the exhibit list and find on the list the number of the exhibit that they want to see. And so she's suggesting, or did suggest in the part we heard earlier, that they clean up, maybe there's some language in the exhibit list that they don't think is particularly appropriate, caption all the exhibits, agree as to what to call them, and then send the list in with the jury. So this issue won't come up again. They'll be able to just run down their exhibit list. And what they want to see is what's called butcher paper, and they're going to change that to bench paper. That's what was used throughout. And I see something from someone in the chat says that Core TV says it's the exhibit showing the blood clot and the clump of hair. And I was going to guess it was that, but I'm glad to see that Core TV confirmed it, or not confirmed it, said it first, so I can confirm that where I was going was correct. And so that's what they want to see, the blood clot and the clump of hair. And they want to know what exhibit it is they need to refer to find it. And she's going to give them a list of all the exhibits. And Ms. Annie Kay said this is the most damning evidence from which DNA was gleaned. I think so too, because I thought that clump of hair reference was really, really compelling. Okay, I missed that last comment as to what the jury wants to see.
And Joe, I'm just hopping on here for a minute just to clarify for those who are just watching. What we just played was a replay of what happened moments ago. So right now in the courtroom, they are back deliberating and we're back to seeing the clock. That's the image you see right now. So we just replayed it for anyone who may have missed it, like myself, because it did happen very quickly. And Joe, now that I have you here for a minute, are you surprised with deliberations so far? I know a lot of people were saying that they thought the evidence painted a very clear picture of what happened to Anna Walshe. Are you surprised that we're 3 hours in and so far nothing, just a question, wanting to look at more evidence?
I'm not surprised exactly. They did take lunch. And I said earlier before we broke that I could imagine them coming back right away if they were just convinced and they took one vote and they were 12-0 and they were done. This suggests that they're looking at some of the evidence, probably to decide, or to probably focusing on what was the cause of death. The clump of hair and the blood. That blood doesn't even sound like whether it would be intent or premeditated murder. It really sounds as though the question that they may be thinking about a little is, was the cause of death some violence perpetrated on her? So I guess I'm not surprised. If it come back right away, it was clearly going to be a guilty verdict. There's no question. There was a lot of evidence, there were a lot of exhibits, and there is that issue as to whether he intended the death, whether he premeditated the death, and the defense kept hammering on there isn't any evidence that he even caused the death. So it may be that that's what they're looking at. So long way babbling around to say, I'm not surprised, but I wouldn't have been surprised if they came in after an hour either.
And I did just want to share some poll results from the STS chat. I believe 2,500 people chimed in, and we asked them when they thought the Brian Walshe verdict would come back. 18% said under an hour, 68% said 2 to 3 hours. So that's the window that we're in right now, because we have 3 hours and 17 minutes on the clock. But again, they did take an hour lunch.
Right.
And then 12% are saying Monday, 2% are saying Tuesday. So right now, we'll see whether or not the STS chat is accurate or not, because it's another hour or so, according to the poll.
Well, what we will also find out is, since we're going into the weekend, if they're close, well, we'll have to see. But if they're close and they're still wrestling with it, we may find them asking for more time today to get it done today. So if at the end of whatever it is when she would send them home for the trial, if they were ending at 4 every day. And I don't know what she does. I mean, I'd be surprised if they go home at 4 while they're deliberating, but they could. So we will just now have to wait. She said what's interesting to me is she said her typical practice is to send the exhibit list in with the jury, but she didn't do it this time. So whether it must have been an oversight maybe. And so now it will take them a little time because she's got to clean up the exhibit list so there isn't language like butcher paper, and they use bench paper instead. And both the prosecution and the defense are going to have to review it to be sure that they're satisfied with what will go to the jury. And if the jury really has an interest in this particular exhibit, they either are not deliberating right now or they're talking about something else, but they'll have to come back to this. So my best guess is they will be delayed more than the time it takes before they get the exhibit list.
And what about poetic justice here? He's saying that the instructions were very confusing. Obviously, the jurors are taking their time. They're looking at exhibits. They're asking questions and looking for more information. But talk to me about this comment right here.
Yeah, I thought, in fact, poetic justice, I guess I disagree with you. I thought they were, these instructions that she was using for Massachusetts were remarkably clear compared to others I've heard. The consciousness of guilt instruction, the instruction on what's evidence and what's not evidence. I thought that was the best instruction I've ever heard on telling the jury, this is what the evidence is, and it's not this, and it's not this, and it's not this. So if poetic justice found them confusing, these were typical jury instructions. And so he would find them confusing in probably a lot of different criminal cases. So, and Ollie 1951 agreed with me. She or he thought they were very clear. Julia Ballo says they were too long. Well, you can quarrel with jury instructions for being too long. I'll grant you that. But they tend to be long because typically, and in this case for sure, they gave examples of what some of the instructions meant. And they want the instructions to be really clear. Jury instructions serve two purposes. One is clearly to tell the jury, here's what the law is, and here's what you have to apply your fact finding to. But the other purpose is to survive an appeal. And so if the jury instructions are given in a legally correct way, then there is really no appealable issue for the defendant on any one of the instructions. And so sometimes, historically, they were extraordinarily unclear because they would do the language of the statute, and they would have all kinds of language in there, and they would all be general language. They wouldn't be particular to even whether the defendant was a woman or a man, or even if there were more than one woman, because they were just taking the language that had been approved by the court in who knows how many years before. They were very, very unclear. And there was about 20 years ago, maybe a little more, an effort to make them clearer, to get them in everyday English, to particularize them. So if you've got a female defendant, you use she, you don't do he, or you don't do he or she. And so they're much better than they were. But I would agree that they're not perfect by any means. So.
And Joe, I just want to let everyone know that's listening. If there is a verdict, we do have a game plan. We will end this stream and redirect you all to a new stream that will say verdict reached. It'll be obvious. And again, if you're here, we'll redirect you. If you leave and come back, you'll see the new stream, whichever stream we're live on. That's obviously the one with the update. But we don't know whether or not that's going to happen today. If it does, obviously we'll take it live. We'll see what happens, whether or not she allows them. Did she say she would allow them to work into the weekend?
She didn't say. And
okay.
So I don't know. Will you do, if they come in today, will you do a show tonight, or will it be the verdict reached supplement show and then nothing tonight as a recap?
We will do nothing tonight as a recap, just because we have the events with Tim.
Oh, sure.
So we would just do the verdict reached, and then Joe, if you plan to do a recap,
I will.
then you can let everyone know to follow you.
Yeah, I will. I'm asking because earlier today I didn't know, and so I told the chat that they should look to see on your channel alerts whether there would be something. So as long as you're here and I could ask.
Yeah, yeah. So
That
we'll
clarifies it.
just
Great.
do this verdict watch, and then again, obviously, when there's a verdict, we'll do that, and we'll take that live as well. But in terms of actual shows, we won't be doing any shows until Monday.
Okay.
Yeah. All right, Joe. I'm here in the background if you need me for anything.
Okay.
All right, I'm
Let's
gonna
hope
hop-
they come back with a verdict soon so everybody can have a good weekend.
Yeah, exactly. And again, let's all remember that this is about Anna Walsh. She's a mother of 3 little boys. 2 of her boys happen to be the same age as my little kids, and these are tiny little kids who have lost their mother. Now we're losing their father, and now we're in the state system. I mean, they're in foster care, and who knows what's going to happen to them. So again, let's remember Anna Walsh, and let's think of those 3 little boys. Thanks, everyone.
Thanks. And of course, the CEO is exactly right. The focus should be on the victim and the children. And I mean, of course, it's a trial, so we're focusing on the person who's been accused, but really the heart of this is a mother and what's happened to the children. And we think we know they're in foster care. I don't know whether all 3 of them are together. I think it would be an additional just terrible, terrible thing if they had to split them up in foster care. So I don't know. And until somebody tells me differently, I'm just going to continue to hope that they're at least all together. So since we're sitting here, I'm going to sit here a while now because I don't want to miss another something. I don't even know. I have my work up in another room. I don't even know if I can risk going and getting the work so that I can do something while I'm sitting here. So. But evidently some of you stayed and had it on at least in the background. I'm sure you didn't. I'm sure you didn't sit looking at the screen with a picture as we look at it now, which was a whole lot better than that fan that kept whirling around. So what we know is they are working. And you could see how fast everybody got back to the courtroom. The prosecutor, I don't know this setup in where they are in Massachusetts, but everywhere, the prosecutor's office is very close to the courtroom. Sometimes it's in the same building. The prosecutor's offices would be on different floors in a courtroom that has all the courtrooms and the judges' chambers. Sometimes it's right across the street. Sometimes it's next door, but they are very, very close. And the defense lawyers, I don't know where their offices are, but I suspect that that they've been provided space somewhere in the building where they can sit and wait. I don't know where their offices are, but certainly they would not want to go back if their offices are a ways away to have to come in. So I heard the COA talk about the poll that they did. We did one on Prof. Joe Explains also, which, and we're going to put it up for you, which, as I recall, what the COE said is pretty close to what those of you who are watching on the STS channel voted on in your poll. So let me see if we can get it up so you can see it. I always think it's better to see and not just hear, particularly for those who receive information better visually than through audio. So we will wait a second. You can sit there with bated breath. I know the answer because I can see the poll. So just hang on and we'll see if we can get that up for you. So. Well, while I was waiting earlier, my phone rang while we were on. I don't know if you could hear it this morning, and I took a minute to return the call because I was afraid I'd get another call. And it was somebody, as it was a florist delivering a poinsettia plant. And while we were on break, he actually delivered it. And I can report to you that it's a beautiful plant. Although poinsettia, for those of you who've had one, are notoriously fragile plants, and they take a lot of care and attention. And I'm going to have to worry about this plant now, which is one of the reasons why I don't have a pet. Now I'm going to have to worry about the plant. But so, Amber, do you think will we be able to get this poll up, or oh, she's doing a fresh screenshot of it. Okay, so let's just hang on. So, any questions from anyone? I don't know what they would be right now, but if you do, I will try to get to them. Okay. Oh boy. Okay, Neely 888 came on late and asked, did the jury have a question? Yes, we didn't hear the question, but it evidently referred to an exhibit that the jurors want to take another look at, and they didn't know which number it was, so they sent out a question. Now, this is my speculation based on what we heard from the judge, for information as to what exhibit number it would be, and she's going to tell them the exhibit number, but she also decided that she should send into the jury an exhibit list. So if they have another question like this, they can refer to their exhibit list and find the exhibit that they want. And the exhibit that they wanted was what's called, I believe, a bench paper. And we believe that's a paper. Oh, here we go with the poll. But we believe that that's a paper that had the clump of hair in the blood. Okay, so here's where we are on the Prof. Joe explains poll with more than 900 people voting. 75% of us believe it will be murder 1. 22% believe it will be murder 2. 3% believe the jury will hang. Nobody believes the jury will come in 12 zip for an acquittal on murder 1 and murder 2. And that's pretty close to what the STS poll showed, except I believe they did have a percentage of 2 saying not guilty. So here we are. We're 97% that he's going to be convicted of murder, either 1 or 2. And then we have most of us, and I voted with the 2 to 3 hour group, that the jury would be back in that time frame. 68% of us, which is almost 7/10, thought it would be 2 to 3 hours. 18% thought it would be an hour, and there were 12% who thought it would be Monday. And it's looking more likely that it would be Monday, depending on how late the judge will allow the jury to deliberate tonight, because we've had this delay. I believe that by now she has the exhibit list ready to go, but we have no way of knowing. And if she sends it in with the bailiff or one of the guards, she may send it in and we won't even see it happen. So we won't know when the jury got the exhibit list. She had said that her practice is to send an exhibit list in with the jury, and she obviously didn't do it this time. So the jury will have the exhibit list and can go. Earlier today, they had a discussion that you may have seen about the knife and they didn't actually say the hacksaw, but all those, they're now calling it tools before the jury rather than weapons. And you may recall that I had said to Joel the other day when we were looking at the hacksaw that, exhibits go go into the jury room with the jury so that they can look at the exhibit. They can physically look at the exhibits. They can touch them. They can move them. But when it's something like a gun, or a hacksaw or a knife, you have to be careful about letting the jurors have it. I mean, an accident could happen, but what I had said to Joel was they might get into a heated, argument, and somebody in the heat of passion would grab one of them. So the judge talked to the prosecutor in particular, because the prosecutor's got the burden of proof, and the prosecutor is also the one in terms of the management of things, the video equipment, the monitors, or the laptops, or that the jurors might have. That usually is the prosecutor's office that arranges all that. Defense uses it as well as prosecutor, but it's usually the prosecutor's office that is responsible for getting that all together. And she said that her practice in the past was to get boards. I don't know whether she said cardboard, but something, and then the knife or the hacksaw would be mounted on it and made permanent, affixed permanently on it, so the jury could look at it, but they wouldn't be able to pick it up and do anything with it, or have an accident and have it, the hacksaw drop on your toe or something, which would be something I would do. And so they had said on one of the breaks that they would work with the sheriff's office or their staff, and they would get that done. And so that was done, and that's what the jury has in the jury room with them. Plus, the jury has all those, remember all those brown bags tied in the red tape, which I thought was really visually very, very compelling, because it, looked like the red tape, suggested blood. They have all that in there with them. They've got the videos. They will have a video recorder so they can play any of the videos if they want to review anything that was shown during the trial. Audio tapes, they'll have an ability to play the audio. So they just don't have to look at physical evidence. They can hear and they can see the evidence. What they will not have is anything that was called a demonstrative exhibit. And I don't remember offhand if there were any here, but a demonstrative exhibit is not an exhibit. It's not been entered into evidence. It is used to illustrate, to help show the jury something so visually they can see it, they can understand it, but it is not evidence, so it doesn't go into the jury room with them. And the judge did refer to at least one or two exhibits that were marked for identification, but were never entered into evidence. If they weren't entered into evidence, the jury does not have them. So we're now at 3 hours, 36 minutes, almost 30 seconds and counting. And I think this question was resolved. I do not believe that she is going to come back out and do anything on the record. And so therefore I'm going to stay here for a little while just to see if anything happens. But, and the stream is up, but I think nothing will be happening for a while. The next time something happens will either be a verdict, a report that they are unable to agree, or another question. I just saw a question here. If I see questions in the chat as I'm sitting here, I will raise them and let you know. I see a question in the chat from Angela Grace. No, it's not Angela Grace. Sorry. Artfully Becoming. Will I be on STS tonight? The COE, you may not have heard her. They are not going to, the STS will not have a 7:00 show tonight. They have events associated with a wedding that they are attending. It's Tim Jensen's daughter. And so they will not be having a show tonight. The next show they will do is Monday. But if there is a verdict, Joel will come in for the verdict, and then there will be some period of discussion for questions and commenting after the verdict is delivered. And I will have a show at 5 o'clock, just wrapping up today. I'm I'm asked if I'm drinking brandy. I guess that would be the color of brandy. I would think of it as bourbon, actually. No, it's a tea. And I see Coco 15D is now, I believe what she's telling me is she is a subscriber. Thank you very, very much. Okay, UK introvert wants to know if we know if there is a time cutoff for deliberations, or can the jury go as late as they choose. I didn't hear her say anything about it when she submitted the case to the jury and sent them off to deliberate. I don't think she said anything, because I remember the end of it, and I don't think she said anything at all about it. So I don't know, and I don't know her practice. Some judges will go to 5 if that's their normal hours. They will stay later if if they're giving some inclination from the jury that the jury is close. Otherwise, they don't typically deliberate over the weekend. It's not impossible. And again, I don't know what the judge's practice is. This is something that really a particular judge running her courtroom makes decisions about. There is no standard rule about it. And you see Cohen's anthem that Josh Ritter he does Courtroom Confidential. On his case notes, he gave the jurors backgrounds, and they include a scientist, an art teacher, an insurance professional, a chief financial officer, a tech writer. We don't know. Remember, there were 16 and now there are 12. We don't know which 4 and which backgrounds are no longer on the jury. And I tried to watch, but both the prosecution and defense were appropriately stone-faced. But I was trying to see if I could get a clue from one side or the other as to whether they were pleased or displeased about the 4 that are now alternates. I mean, in voir dire, both sides make a concerted effort to get jurors that they think will be receptive to the case that they are going to make. And they sometimes, because lawyers only get so many challenges, they sometimes have to compromise and take someone when they're just not sure about that person. They like somebody else better. So both sides would have jurors that they, on the responses and on the background and on the demeanor, that they feel pretty confident would be inclined to be receptive to the case that they are presenting. And they also will have jurors that they're not as sure about, and they will have jurors that they really have questions about. And then when you go from 16 to 12, obviously 4 are not going to be deliberating, and you can lose the juror you think was your, best shot at getting, let's say, a hung jury if you're the defendant. Now, often we're wrong about it. We think, the juror that's just going to be the strongest for our side turns out not to be. But nonetheless, we do make some educated guesses about it, and then you lose 4. And so one side or the other might feel that now it's a better jury given their picture of the jurors, or it's not as good a jury as they thought they might get because of the particular backgrounds, demeanors, and answers to questions of the four that have been that have been pulled out of the hat or the whatever it was, the basket that they were using, and are alternates. The alternates are still there because there still could be a juror could get sick, a juror could have an emergency at home and not be able to finish out deliberations, and then they would, draw out of the hat or basket or whatever it was, and one of the alternates would go in to replace the juror that had to leave. And then, as you heard the judge say, the jury, in deliberations, they would have to start at status quo ante and go through everything again because the alternate has to be privy to the full discussion, the full exploration of the issues in order to vote at the end. Now I'm getting a message here. Is this a new message or another one? The attorneys are coming back again. So who is in the courtroom that's telling us this? I mean, thank you very much, but who's there? So we're either getting another question or they're done. Yeah. Amber, one of my mods and also manager over here, has said that the lawyers are coming back. Oh, it's people in the chat that are reporting. I've got the chat in front of me. Why didn't I see that? I should pay less attention to talking and more attention to reading. Although someone in the chat this afternoon said I should watch more to get a better feel about what's happening. But I'm sure she didn't mean watch the clock and the picture and myself. Okay, so they're coming back. The chat is reporting. We must have somebody in the chat who's in the courtroom or who is hearing from someone in the courtroom. They're coming back again. I'm glad I didn't move because I would hate to again miss the first couple of minutes. I also saw a couple of comments from people saying it was nerve-wracking. I said before we broke that it is, if you think it's nerve-wracking watching as a spectator, just imagine what it's like after you've presented a case. I said earlier today, it is the most, I have never experienced anything like it. You cannot think about anything else. You cannot concentrate on anything else. You can't do a thing. You can try, but it just, your brain will not let you do anything other than think about the case. What could I have done differently? Why didn't I do this? Why didn't I say this? I mean, it is just a nerve-wracking, incredibly nerve-wracking experience for the lawyers, but in a way exhilarating because, how many things do you do in life where your attention is so gathered and focused on one thing and nothing else? So we'll wait for the lawyers, and this time we're ready. I hope if it's another question, she reads the question in open court. Most judges do that. They will have the lawyers come in, they will read the question to the lawyers, and then there will be a discussion about it. What she did was she talked to them or showed them the question, I guess, in chambers. And then they came out in open court, but we never heard the question. Okay. Illuminating Inc. wants to know about jury deliberations. When a jury says they are hung, why can't they call in an alternate to replace ones who are deadlocked? That would be unconstitutional. You are, as a defendant, entitled to the jury that is impaneled and sworn. In this case, you had 16 impaneled and sworn, but then they draw and you got 12. Think about it. If the jury is deadlocked and you could simply bring in an alternate, the jury might be deadlocked. The individual juror who is causing the deadlock may be a vote for acquittal. So if you could just, merrily replace that juror with someone else, you have violated the constitutional rights of that defendant because you have lost her the opportunity of at least a hung jury, or the opportunity, if the judge had said, go back in and talk some more, of that juror persuading the other jurors. So you cannot do that. Oh, let's see. Karen Cole, UK lawyer, said the verdict clock paused, but I'm looking, oh, now it has. My screen is a little slower than what Karen Cole, UK lawyer, is seeing. Yeah, it has paused on 3:47:49. I didn't notice if it paused the last time. Well, I didn't notice because I wasn't here for the first 2 minutes. Did anyone notice if the clock paused the last time? Anybody in the chat notice? It didn't pause the last time, according to Ellen Jaya. Oh, it looks like maybe she's going to dismiss them for the day.
Thank you. As is my custom, at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in, send them on their way.
So that says they're not within.
ID still marked.
That says they're not within 15 minutes of coming to a conclusion. It's interesting, though, that 4:30 is her limit as to how long the jury.
All rise for the court. Jurors entering.
I'm gonna go see Mom, but otherwise I would maybe on Monday if we're.
I would say that the defense lawyers have to feel pretty pleased that at least they've got a jury that's taken 3+ hours and thinks it'll take more than 15 additional minutes.
Welcome back, jurors, to the courtroom. And thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. Continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend. Get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors.
Thank you.
All right, for the court, please. Jurors, follow me.
Thank you.
I will thank Elizabeth Kim from STS. She gifted 20 memberships. That's really very generous.
Just as short as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.
Okay, she wants the lawyers back before 9. She said a few minutes before 9, so I'm guessing maybe 10, maybe 15 minutes, no more than that for sure. Okay, the court is done for the day. The jurors are released for the weekend. Sometimes after a weekend, things get done very quickly on Monday. We'll see on Monday whether that's the case. Okay. And Neely 888 said, Joel has to be happy that he will be there for the verdict. I'm sure that's true. You don't want to watch the trial and miss the verdict. Okay. And I will say that, as I said just a moment ago, the defense has to be pleased that they have at least succeeded in, from their perspective, getting the jury to talk about the case for what, 3 hours, maybe a little more, less than 3 hours because of lunch. And we'll see what Monday brings. Okay, artfully becoming, do I think if he doesn't get murder 1 or 2, he will ask for bond before sentencing on the other 2 charges? I don't know the answer to that. Typically, defendants do try to get, not have to sit in jail. So it wouldn't be a surprise if he asks for bond, but we shouldn't go there until we know. Let's see, how many years do I think we'll get on the other 2 counts? The maximum for the disposing of a body is 10 years unless there's a finding that the body was disposed in connection with a crime for which you could get life imprisonment, which is obviously murder 1 or murder 2. And then the judge has the option to go to 20 years. If by some chance he's acquitted of murder 1 and 2, and they get to that, the judge had said that it's the prosecutor's burden, but he could make the argument and present whatever evidence that this crime was committed in connection with murder. Even if the jury came back acquittal, it would be acquittal on a proof beyond a reasonable doubt standard. The prosecutor's burden to show it was in association with a murder would be a lesser burden than proof beyond a reasonable doubt. And at least what the judge said last week, they would then, obviously the defense would make argument about it also. She would have to make a finding whether this was a disposal of a body in connection with a murder. And if she concluded yes, based on that lower burden of proof, she then could sentence up to 20 years. He also has the sentence on, he also has the sentence on lying to law enforcement. I believe that had a 5-year maximum, but somebody in the chat can correct me if I'm wrong. And that could run consecutive to whatever the sentence is on the disposing of a body. Okay. Allie Foley said when I was, I guess, with a juror in Boston, we took 2 days to deliberate and the defendant was found guilty of murder 1. Them going home is a good thing in her opinion. And she's being consoling because she's telling you that the jury took a couple of days and they came back with murder 1. And, and that a jury that is taking it seriously might very well say they may have taken a preliminary vote. Juries can do it different ways. They may have taken a preliminary vote and I'm only speculating, but it is possible and it has happened that they come in 12-0 and then they say, but let's now go through the evidence. In fact, I think this was what happened in Donna Adelson's case. Let's go through the evidence and be sure. Let's go through everything and talk about it. We think it's a conviction for murder 1, but let's go through, because this is really important to the defendant. Let's go through everything, review everything, and then decide. So I see the COE is here. Hi.
Hi, I just wanted to hop on and say thank you so much to you, Joe, and also to Space Coast behind the scenes. You guys have been manning down this trial for 10 days now. So I just wanted to thank both of you. I also wanted to remind everyone in our chat and watching on our side that if you haven't already, you should go over to Joe's channel, Professor Joe. It's Prof. Joe Explains. And she does live recaps every day after the trial. And I believe today she's doing one at 5 p.m. Eastern time. So that's in about 30 minutes or so. I also wanted to say, Joe, again, thank you. If you want to end the stream, you can. That way you have a 30-minute break before yours.
Yeah, I will, because I don't see any questions coming up right now. And we all want to wish you a lot of fun at the party tonight. And the wedding is tonight, or this is the pre?
This is the pre-wedding festivities. Yes, they start tonight.
We'll have a lot of fun at this and at the wedding, and give Tim our best and congratulate him.
I definitely will, and we'll be posting some photos and videos on our Instagram channel. So if you don't follow us, definitely check us out. I think it's, what is it, Joel? Your Instagram? Okay, he says it's Surviving the Survivor. So just type that in on Instagram and you can follow along. We're going to start posting some photos and videos tonight. And again, thank you to everyone. Thank you to Joe. Thank you to Space Coast. Thank you to Steve Cohen behind the scenes. Thank you to all of our amazing mods on both channels that have been working together. And thank you to all of you, STS Nation. We appreciate you guys. We're going to be live back here Monday morning, 8:45 a.m. Eastern Time.
Okay. Everybody have a good weekend.